set out new requirements for couples getting married. 3 months' notice will be required, and the minimum age for marriage will be raised to 18 under the terms of the Family Law Act, which comes into force on the 1st of August. But these new requirements have been condemned by the Professor of Canon Law at St Patrick's College in Carlis. Dr. Maurice Dooley believes that Catholics shouldn't regard themselves as bound by the law, and he's on the line now to tell us why. Good morning, Dr. Dooley.
Good morning, Anya.
Why should the state's laws on marriage not apply to Catholics in this instance?
Because they're in conflict with canon law, the law of the Church, in several different areas.
Is state law not superior to canon law?
By no means. The law of God is superior to state law, and canon law is intended to state and implement the law of God.
Canon law may apply surely to people getting married in church in terms of their religious beliefs, but the marriage is also a civil act under the Family Law Act. It's required to be registered with the state. Surely the state is free to lay down its own requirements in that regard.
The state is free to demand registration of the marriage, certainly, and is also free to impose reasonable regulations, but it cannot violate the person's fundamental right to marry, and that is what these laws are doing. For example, the canon law sets the age of 14 for a girl and 16 for a boy as the minimum age for marriage. The state claims it's going to raise that to 18. Now that is in direct conflict with the canon law, which states that only the supreme authority of the Church can establish such impediments.
Surely you're not arguing, Dr. Dooley, that girls as young as 14 should be able to decide to get married. After all, people can't vote until they're 18. Isn't it sensible that they should have to wait until then before they decide to get married?
Certainly not. The Church has always traditionally regarded the fundamental right of freedom to marry as applying from roughly the age of puberty, because after all, these people have sexual urges around that time, and these can be lawfully fulfilled only within marriage. Then a person must be free to marry around the time of sexual puberty. That was the traditional law of Church and of state.
But given that marriage is for life, given that it's such a serious commitment, do you think 14 is an appropriate age at which somebody should decide to go into that state?
For some, yes. For some, no. And when the state prohibits all and sundry from marrying under the age of 18, that to my mind is too much of an invasion on their fundamental right to marry.
But there is a provision whereby people can go to the courts and get an exemption if they can put a case to the courts.
Yes, that's certainly true. But however, a better way to put it would be that they allow everybody to marry, and in individual cases you would prohibit it. If you take, for example, the other regulation there, the one requiring 3 months' notice, that to me seems to be a pile of bureaucracy which has no real purpose. The Church wants notification of marriage so that in individual cases, where necessary, adequate counselling can be provided. And for that reason, the Church's viewpoint on this prohibition of marriage for a period is that it has to be done in individual cases for a specific reason, and for only as long as that reason lasts, not a blanket prohibition on all and sundry marrying for 3 months.
But marriage is such an important decision to take in terms of your own life, and it's not just your own life, it's the life of your partner, it's the lives of the children that the couple will hopefully have. Surely it is sensible that people are mature when they make that decision, and that they don't just rush into marriage.
I'm all for maturity. I'm all for not rushing into marriage.
Well, allowing 14-year-olds to get married at the drop of a hat doesn't sound like you're allowing for that, does it?
No, I'm not proposing that 14-year-olds be allowed to marry at the drop of a hat, but I'm saying that some 14-year-old girls and some 16-year-old boys can have the maturity for marriage. Quite a few of the 17-year-olds could have it, and the state is blocking them all. It's infringing too much upon the right of freedom to marry.
Really, Dr. Dooley, at the bottom of all this, isn't it really about a clash between church and state over marriage and the family, that increasingly this is something that the state is regulating and setting its authority on in an area where traditionally people looked to the church?
That's exactly true. And to my mind, the state is infringing far too much. It's